Good morning, this is John Lynch of Lynch Solicitors in Clonmel, and this morning we're talking about family law and in particular cohabitees and various agreements that should be made, recommended to be made for people either in a marriage relationship or otherwise. The first one, I suppose, that you could talk about in time anyway, might be the prenup. And the prenup, basically, the general feeling out there is that a prenup is for people with a lot of money. Not necessarily. It can be for people who have assets that they had prior to entering into a relationship, and they want to ensure that those assets are, let's say, secured for somebody other than the person they're marrying. So you might have a rental property, or you might have a share in a company, and it might be a family business, or you might own the asset with somebody else, and you might want to make sure that that other person, i.e. the other co-owner, might benefit in the event of your demise and or the breakup of your relationship. So that's the context in which you might enter into a prenup. Quite commonly, where you have family businesses or a family farm, it's also something that can be considered. The big question, of course, with prenups is, are they enforceable? I can't give you a straight answer on that, insofar as it hasn't yet been decided that they are not enforceable. So I suppose on a negative or positive take on a negative note, you'd argue that they would be taken into account by the court in the event of a breakup. And I suppose the other thing to say is that with the kind of change in attitude of the Irish Supreme Court and I hasten to add, in ample resources cases where there's a lot of assets involved, the kind of Supreme Court has taken the view in areas like the second bite of the cherry, when there would have been provision either under a separation agreement or a judicial separation, that when they come to relook at it again in divorce, the courts have taken the view that it's not a matter of distributing assets or dividing up assets between people. It's a question of proper provision, and therefore they are less inclined to take the approach in a divorce situation where there was a prior separation agreement or judicial separation to look at everything again and divide up everything equally between the parties. Now, again, the thing to remember in that is we are talking about a situation where there's more than enough to go around. So back to your prenup, if you take that is the current attitude of the Supreme Court, you would imagine that might find its way into interpreting a prenup agreement. And the final point to make, of course, is that the overriding consideration of the court is to be fair, and that fairness is kind of fed into the principle of making proper provision for all of the parties to a breakup, to the couple and the dependent children. So it's only when proper provision is made that you can probably then go to the next stage, which is deciding that if there is a surplus, how it's dealt with. And if there is a prenup agreement, one would expect that the prenup agreement would have an impact on how that's dealt with. So the next thing, of course, that you're talking about, not of course, but the next thing that you'd be talking about is that if people aren't married and they're living together, can they regularise that situation? And the answer is yes, they can. They can have what we call a cohabitation agreement. And that cohabitation agreement can, again, be like a prenup. It can deal with all the various elements that they need to look at, from children, pension, maintenance, assets, etc., and how they're addressed or dealt with in the event of, and again, not to be too basic about it, the two eventualities: either the relationship breaks up or one of the parties dies and therefore the relationship breaks up. In those circumstances, then the cohabitation agreement would be relevant. The thing to remember, of course, is that if there is no cohabitation agreement, then you're left with the option under the Cohabitation Act to actually make an application to the court, to a court, and the two different scenarios are on the breakup. If there's a breakup, then within a certain period of time you are entitled to go into court and say, as long as you qualify, you're entitled to go in and say, I have a financial dependency, or had a financial dependency, and therefore I need to be looked after by the other party. And that the second thing is that if the other party was to die, in those circumstances you can make an application against or to the estate of the other party. The essential difference between the two is that you don't have to establish financial dependency in the case of a succession, i.e. in the case of looking to make a claim against a deceased estate, a deceased partner's estate. As well as being a cohabitant, and being a cohabitant can be a matter for dispute, of course, because you have to be in an intimate and committed relationship, and that's something that you must prove to the court. The second element is that you have to be a qualified cohabitant, and to be a qualified cohabitant, you have to fulfill the criteria of 2 years or 5 years. So you have to be in a relationship with somebody for a period, an intimate and committed relationship with somebody for a period of years in order to qualify. If there are children, and if there are no children, it's a longer period of time. I say it's a longer period of time because I think it's 2 years and 5 years. Now, the second element to that is, so once you prove that you're a qualifying cohabitant, you can then get the protection under the Act. So there you are, a prenup and a cohabitation agreement. Are there other agreements? Yes, you can have a separation agreement, and a separation agreement is effectively when you separate that you can enter into a formal agreement, well, an agreement with the other party, and that then can deal with all the issues that would normally be dealt with by a court if you're going in for judicial separation or a divorce. The final one to make a comment on or to talk about is that, and again it's in the context of agreements, and that is that if you're in a situation where you own an asset with somebody else, it's always recommended that you have a co-ownership agreement with that person. And a co-ownership agreement effectively is just an agreement as to how the property is going to be owned by these 1, 2, 3 or however many people own the property. And that's, you enter into an agreement that sets out what happens if, and the what if scenario if somebody were to die, if somebody wanted to let's say sell the property, if somebody wanted to sell it to somebody else, so you'd have various arrangements to deal with that situation. And the other point to make here, of course, is that if you're a co-owner of property, you do have the option to apply to a court to actually partition and or sell the property, and this is something that can be covered in the context of an agreement rather than to have to rely on a court application. So again, just by way of brief summary, if you're living together in a committed relationship, it's advisable to have a cohabitation agreement. If you're entering into a marriage and there are substantial assets involved, and or there are assets involved that other people are interested in, or there are assets that you own yourself which you want to retain control of, then a prenup agreement may be of assistance there. The other thing, of course, is that if the marriage breaks down, and if you're in a position to talk to the other person and negotiate terms, you can enter into a separation agreement. This is John Lynch of Lynch Solicitors, and again, thank you very much for listening to me, and hopefully you're all safe. Thank you very much. Bye-bye.